A federal court in Alabama has ruled the Corporate Transparency Act unconstitutional, but only for certain businesses, a move that's already causing confusion for ag entities. Our good friend Roger McEowen with the Washburn School of Law joins us in studio for some guidance. It is so nice to have you in the studio, by the way, and not see you on the screen there. So thank you for being here. So really, when we talk about the Corporate Transparency Act, this really was created, in essence, kind of an anti-money laundering initiative. So what are the courts saying now with this?
Well, Suzanne, and it is good to be with you in person. We've had a federal trial court in Alabama. The judge has ruled that the act is unconstitutional. Now, in the Corporate Transparency Act itself are these new beneficial ownership information reporting rules, which apply to a lot of farming operations across the country. And those don't take effect until we get to January 1 of 2025. So everybody's kind of concerned about it right now in terms of what information do I have to gather that I have to then file with the Financial Crimes Network, which is a branch of the Treasury Department.
So when we're talking about the beneficial ownership information, the BOI as it's known, this really implies that it's ownership of 25% or more. So for people that have investments, that are making funds, that have money coming in, I mean, this is all out there for taxes, the IRS to see what people are claiming.
And that's a large point of what the court was talking about here. A lot of this information is already gathered by states. And this is particularly the domain of state governments. When a business is registered with the state, that information is collected. Now, states have different requirements from state to state. But what the federal government did here, they argued that this was legal, this was constitutional, largely under the Commerce Clause. They made some other arguments also, but the Commerce Clause is the clause that sweeps up all type of economic activity and says that the government can regulate that. Well, the judge here said, you didn't tie the requirements, the beneficial ownership information reporting requirements under the CTA to economic activity. You didn't tie it to commerce. You tied it to simply being registered with a state. Well, I could register my business but not conduct any business activity.
Right.
And I'd still have to report, and the court says, no, you have to have business activity to trigger the Congress's authority to act. So we shall see. This is going to get appealed. And whoever loses the appeal will take it, I guarantee you, to the Supreme Court. So unless Congress acts, and they won't until they absolutely have to, I think this is going to stay in kind of limbo throughout the rest of 24.
So bringing it back to our farmers producers, what do they specifically need to know in regards to this?
Okay, that's a good question because I'm getting that one a lot. And what I'm telling people is that you need to talk to your tax professionals and particularly your attorneys. And I think the burden is largely on the attorneys that form the organization for you. Get them the information that the act requires. And then don't file it. Sit on it and wait to see what the courts say. There's no need to provide information to the government that they may not actually be legally entitled to. But go ahead and be ready to file it if you have to at some point in time, depending on what ultimately the U.S. Supreme Court says.
And we're going to be waiting on this. So how it moves forward and depending on what they say in these rules. So this is just a wait and see game at this point?
It is a wait and see game right now.
Yeah, interesting stuff. As always, thank you, Roger, for breaking it down. I know a lot of information, as we say, can get confusing. Roger McEowen, thank you so much. He is in studio with us. By the way, he's going to be sticking around. He's going to be joining us in the next half hour. Looking forward to that.